Hello, everyone, and welcome to today's webinar, Navigating Legal Risk of AI in the Workplace. Today's webinar is being recorded, and you will receive a follow-up email within 24 to 48 hours with a link to view the recording and a copy of the slides. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them at the end of the presentation. Today's presenters are Lisa Bronner and Slaven Jesic. I will now turn it over to Lisa and Slaven.
Good afternoon, everyone, and welcome. My name is Slaven Jesic. I'm an attorney in Whiteford's technology and intellectual property practice. My own practice primarily focuses on intellectual property matters and the intersection of law and technology, including the intersection of law with emerging technologies like AI.
Good afternoon, I'm Lisa Bronner. I'm a partner in Whiteford's New York office, practicing labor and employment law.
Next slide, please. And just as a quick preliminary matter, we need to cover the presentation disclaimer. The information contained in this presentation is intended for general information purposes only and does not constitute and is not intended as legal advice. Next slide, please. So why focus our presentation today on AI in the workplace? I think we all appreciate the widespread availability of AI tools and the growing adoption of these tools by the general public. The use cases in the workplace as well that will drive many efficiencies are also almost infinite. And getting ahead of this issue with your own workforce is critical in managing the associated risks. Now, what makes the discussion of AI in the workplace interesting and AI in general are some of the unique risks and challenges that the emerging AI technologies present. Next slide, please. And so when we're talking about this emerging technology, what is it? It's important to note that each law and regulation that we discuss today will have its own definition. And it's really beyond the scope of our presentation today to go into the deep comparative analysis of those definitions, which are just getting more and more complex with time. However, we did just want to grab a few minutes to go over some basic concepts and some terminology that will be useful for our discussion today. So when we're talking about AI, I think it's helpful to think about two primary components. One is the algorithm itself, and the other is the data set on which it is trained. So we're primarily talking about algorithms that are trained on typically very large data sets to learn patterns and relationships within the data, and then to really take those learnings to make predictions, decisions, recommendations, and to generate content. So basically, it's software that's capable of imitating intelligent human behavior, human learning, and human decision-making. When it comes to generative AI, as the term implies, we're talking about AI models with abilities to generate output like textual responses, 2D images, and even video content in some instances. And this is really just in response to natural language questions and prompts from end users. So again, think ChatGPT and other popular generative AI platforms. On the predictive AI side, and again, as the name implies, we're mostly talking about models that are generally aimed at making predictions, decisions, or recommendations. And the risks and best practices that we're discussing today are equally applicable to both the free publicly available tools as well as those that are commercially available for a fee that, for example, your organization may bring in as a tool for your employees under a subscription or a license or otherwise. So we'll discuss those risks. We'll really discuss some general internal AI policy issues that can mitigate some of those risks. And then a little bit later in the presentation, we'll also be covering some points to watch out for in your contract negotiations and your overall due diligence when it comes to AI vendors. Next slide, please. And just to give a little bit more color to the many uses of AI in the workplace, there really is a large number of instances where AI tools can provide workplace efficiencies. And specifically in the HR context and in relation to some of the predictive models that we mentioned, the services range from resume screening to chatbots and other tools that can even interview and evaluate candidates for employment. Their outputs also range, so you can include, for example, scored ranges that indicate either a poor or a strong fit for a specific employment opening, and they may even include additional recommendations on the hiring decisions themselves. So in other words, a yes, no, or a maybe, depending on how a candidate is scored. So without really getting too far ahead on this topic, you can certainly begin to appreciate how these tools may lead to certain biased or discriminatory decisions in this context if they're not properly designed or properly trained. And as this area is also a specific area of expertise for Lisa, I'll just quickly turn it over to her for some additional points here in terms of how AI may pop up in the workplace.
Slaven mentioned a bunch of them, but AI is used in so many different ways by HR. It could be generating job descriptions, job postings, personalized learning and development, predictive analytics to help analyze data to predict which candidates are most likely to succeed in a role based on historical hiring data and performance metrics, customized learning and development, personalized onboarding programs. Just there are many, many ways in which AI can be used by HR in carrying out their functions.
Next slide, please. So we've already touched on algorithmic discrimination as one of the key risks for AI use in the workplace. When we're talking about some of the other primary or key legal risks, we're generally focusing on data accuracy, data privacy and security, confidentiality issues, general intellectual property, specifically IP infringement issues as well, and then a number of breach of contract or potential breach of contract issues that may stem from any one of these areas. Next slide, please. So on data accuracy specifically, one aspect of AI tools that really seems to be underappreciated by the general public is the fact that sort of the garbage in, garbage out principle very much applies to these tools as well. So for example, in addition to output that may infringe third-party IP rights, and we'll obviously get to that separately in some subsequent slides, AI tools may produce incorrect or even nonsensical responses. These are generally known as hallucinations. And so many of you may have, for example, come across headlines about an attorney who used a generative AI tool to create a legal brief, which turned out to contain a number of case citations to cases that simply didn't exist. In other words, they were just made up. And really the cautionary tale and the takeaway for the rest of us is that really the output and the information produced by the AI tool needs to be independently verified, not only as a matter of best practice, but also because the number of these emerging AI-specific laws may in fact require human oversight. In addition, the results or decisions produced by the AI tool may reflect the biased or incomplete data set on which the tool has been trained. There's actually a number of ways in which either the training data itself or the manner in which the algorithm was designed that can lead to biased output. So for example, if the model is trained on data that is collected from a biased survey, or is just generally trained on a non-representative set of data, the model's predictions will reflect that bias or really those gaps in the training data itself. And then also the algorithm itself can be designed in a way that favors certain outcomes. In other words, the designer can decide how much weight to accord to any one factor, and this itself can be a source of bias. And so understanding these limitations and accounting for them in your AI policy becomes critical, especially if the intended use case is involving automated decision making or any sort of general generative output. And so there are really some best practices here that should be considered as part of your AI policies, including the requirement that staff internally disclose the output generated by AI. And this, again, is primarily for the purpose of enabling the human oversight and this independent verification of the output. Next slide, please. And generally, when we're speaking about effective AI policies that really should be developed, these should really highlight to the employees the growing spectrum of these unique risks and limitations. And this should also really include some appropriate points on confidentiality and data privacy and data security risks, which which also don't necessarily seem to be self-apparent at first blush, as I think is also the case with data accuracy. So, for example, the terms that govern the use of many AI tools in the marketplace today, and in particular the free tools, often state that any input can be used by the developer to further train or retrain the models. So once that data is ingested by the model, it is essentially compromised in the sense that a third party now has access to that data without any restriction on use or disclosure. And this, of course, can result in a number of risks to your organization. For example, it could potentially constitute a data breach, triggering notification requirements to affected individuals. It could lead to allegations of false and deceptive practices if this disclosure is maybe not consistent with what you're otherwise disclosing in your privacy policies. And really the key risk that should also be highlighted here is the fact that this could also lead to the breach of contract issues that we mentioned if the information is obviously subject to a duty of confidentiality. And now, of course, it's been disclosed to a third party, resulting in a breach of that obligation. So the key takeaway here with respect to the policies is to really make sure that your policies prohibit disclosure of personal information or confidential or proprietary information into an AI tool where that disclosure would compromise that data. Now, this isn't necessarily true with every tool, like some of those tools that are specifically designed to only retain the data for the duration of the user session, or that do not necessarily further reuse the data. But for a large number of publicly available tools, this may be the case. And your policies and instructions to employees and the associated training really needs to take these sort of issues into account on a case-by-case basis. Next slide, please. So in terms of just continuing with the key considerations here, a key item that really needs to be appreciated with respect to the intellectual property issues is that the AI tools may simply be reproducing content as output without a proper license or a permission to do that. And just to illustrate this point, you may have come across, again, headlines about the New York Times case against ChatGPT and a number of other providers of AI tools. In that case, the New York Times asserted that basically its content, its articles were used to impermissibly train generative AI tools, which really just resulted in the tools generating output that's essentially reciting the New York Times content without a proper license. And really the important point here and the takeaway is that your organization may, in some instances, be receiving infringing content from a generative tool. And again, your policies really need, in your overall training, you need to account for these risks. Another risk that should be mentioned with respect to any particular copyright considerations here are some of the recent developments in the US Copyright Office. The Copyright Office has recently taken a position that works generated by AI would generally fall in a category of works that are without sufficient human input and control, and generally do not qualify for copyright protection. So that basically means that your organization may not be able to claim ownership and may not be able to register a copyright in the resulting work. And while generally important, if you're on a service provider side, and for example, if your organization uses AI tools to generate deliverables for clients, this really does raise a number of significant questions. In other words, can you really warrant title, for example, or that the work is original, or that it's not infringing? So this may really require your organization to revisit, a number of the existing, standard contracts and other terms, as they may no longer be appropriate in light of the AI-generated output that may be emerging here. And just one last point here that isn't necessarily unique to AI, but it's certainly worth mentioning. And that's also the fact that there's an additional risk if your output violates the rights of publicity or rights of privacy. And again, to illustrate this point, we've borrowed some images on this slide from a copyright infringement complaint that was filed by Getty Images against a number of generative AI developers. And you'll see in this particular instance that the output prominently features certain professional athletes. And so, for example, using images like this may come with right of privacy or right of publicity issues if your organization hasn't obtained proper releases and clearances from the individuals who are featured. And really just also worth mentioning here, the output in this case, which is the image on the far right, maintained the Getty image watermark. For an end user in this case, that's actually a very helpful hint that maybe an IP infringement issue may be at play, but as users, we really rarely have the benefit of such obvious red flags, and it's generally very difficult to assess whether the output may or may not be infringing. So in light of all of this, and in terms of how to sort of tackle these issues on the AI policies, some of our clients have been trending towards using this type of content for internal purposes only. Others simply deem the risk to be too great. I guess the fear obviously is that the internal content can always find its way outside of the organization. And so folks falling on that side of the spectrum have generally been more restrictive on both the generation and the overall use of that content within their organization. Next slide, please. And I believe I'm turning it over to Lisa here.
Thank you, Slavin. So I'm going to talk about some employment-related issues. AI tools have the potential to increase the pace of innovation and also workplace efficiency, but do present a variety of legal and other risks in the workplace. Algorithmic discrimination is one that you may have heard of. Also, there are issues with respect to the use of AI tools regarding wage and hour laws, workplace safety, and dangers of deepfakes at work. Next slide, please. So with respect to algorithmic discrimination, and Slavin touched on that a bit before, the overarching message is that employers have to make sure that they're complying with anti-discrimination laws, whether the discrimination is committed by humans or through the use of AI tools. And what can happen is if an algorithm is trained on biased data, as Slavin mentioned, it may continue to make biased decisions, potentially excluding legally protected groups. So there are also accuracy issues, as AI systems may not interpret the data correctly. So if the AI system is trained on biased data, such as the notion that men dominate a particular industry, engineering or finance, or teachers are primarily female, it may unfairly prioritize candidates and overlook qualified ones from diverse backgrounds. So for instance, a 2024 study found that the use of automated decision-making tools by employers to screen resumes and make hiring decisions resulted in discrimination based on race and gender. According to the study, the tool discovered correlations between protected classes and specific job types. In making its predictions, the tool assumed applicants' race and gender based on their names and reproduced those correlations, inadvertently ranking equally qualified applicants unequally for particular jobs based on their names. So for example, the study found that the tool ranked Hispanic women more favorably for a position as an HR specialist than white men, and ranked Asian women as the top candidates for a financial analyst role more than twice as often as Black men based on their names. And the lack of the usual traceable human decision-making process in AI tools makes bias claims challenging, particularly disparate treatment claims. So what you're going to see, and we're going to talk about this a little bit later, is claims of disparate impact, where the claim is a neutral policy had a disproportionately negative impact on a legally protected group. And also, part of the challenge here is that limited transparency around AI decision-making tools makes it difficult to enforce. And we have a lack of really a regulatory framework, which I'm going to in the US, which I'm at the federal level, which I'm going to discuss in more detail later. So the takeaway really is to understand that AI can perpetuate bias in hiring and promotions, and there needs to be human oversight. Next slide, please. So I'd like to give you 3 illustrations of issues around algorithmic discrimination to make the point. So one is Amazon developed an AI recruiting tool that was designed to review resumes and identify talent for a software engineer position. And once they realized that this tool showed bias against women, they didn't use the tool. But essentially what was happening with the tool was that it downgraded resumes that included the word women's. So women's chess club captain, or women's rugby captain, or graduates of all women's colleges. So this is an example of how a tool has the potential to perpetuate existing societal biases. So how did it happen? The AI was trained on existing data, which included a disproportionately small number of resumes from women, leading the system to favor male candidates and penalize those with characteristics associated with women. So we have 2 cases to talk about. One is the EEOC versus iTutor Group. The EEOC, that stands for Equal Employment Opportunity Commission, that is a federal agency that enforces certain federal anti-discrimination laws, like Title VII of the Civil Rights Act of 1964, which prohibits discrimination based on race and sex and skin color, national origin, religion. So the EEOC enforces certain federal anti-discrimination laws and also brings actions, its own actions. So it brought a suit against a company called iTutor Group, and it alleged that the company had violated the Age Discrimination in Employment Act because the tutoring program was programmed to automatically reject female applicants age 55 and older and male applicants age 60 or older, and the case settled. Another case, which is currently pending, was filed in 2023, called Mobley versus Workday. It's a putative class action lawsuit filed in the United States District Court for the Northern District of California. And what's interesting about this case is that it's not against an employer, it's against an HR software platform called Workday, which screens applicant resumes. And the plaintiff, Robert Mobley, a Black man over age 40 who suffers from anxiety and depression, alleges that Workday's AI-powered applicant screening tools discriminate against job candidates based on race, age, and disability. He alleges that he applied for over 100 jobs on Workday's platform with various employers, different employers on the platform, including one where he was working as an independent contractor, and he was rejected for consideration for a job at that company. So what he's saying is that he was qualified for all of those positions, and he was rejected because of biases in Workday's AI systems. So the tools are accused of using biased training data and algorithms that infer race, age, and disability from factors such as graduation from a historically Black college or university, graduation year, and personality tests. The court, to this point, has allowed the lawsuit to proceed, recognizing the potential, as a class action, recognizing the potential for AI providers to face direct liability for discriminatory practices. And you might say, well, how is that possible, right? Don't these laws apply just to employers? Well, they don't. They can also apply to, in this case, the laws at issue, an employer or an employer's agent. And the argument is that Workday acts as multiple employers' agents when it screens these resumes and doesn't allow some of those to go through. So what the court said was the 0% success rate at passing Workday's initial screening, combined with the plaintiff's allegations regarding bias in Workday's training data and tools, and the tool's reliance on information from personality tests and biometrics, plausibly supports an inference that Workday's algorithmic tools disproportionately reject applicants based on factors other than their qualifications, such as a candidate's race, age, or disability, and that at this stage, the allegations are sufficient to allege a disparate impact on applicants with Mobley's legally protected traits. So as I mentioned, the court noted that Workday could be considered an agent of the employers using its software, making it liable under federal anti-discrimination laws. And so really the takeaway from these particular cases is that employers and also AI vendors may face heightened scrutiny and legal challenges regarding their processes. And so you really want to make sure with whatever vendor you're using that you're exercising caution in who you're selecting, and that you are demanding transparency in how the tools, what data the tools are training on, and how the models work. Next slide, please. So wage and hour issues, employers may use AI technology to track employees and make determinations about work hours, set schedules, assign tasks, manage break time requests, and also use AI automated timekeeping systems for calculating pay, for instance. So if an employer is using an AI tool that inputs faulty data or provides inaccurate output, the employer may face legal liability for violating the Federal Fair Labor Standards Act and other state and other state labor laws. Next slide, please. I also wanted to just touch upon the many ways in which artificial intelligence is really becoming a transformative force in enhancing workplace safety across various industries. So for instance, predictive analytics through AI tools, where the AI tool is analyzing vast amounts of data, can help predict potential safety hazards before they happen. So they can then prevent accidents, injuries, worker deaths. And so it allows companies to take a more proactive approach to mitigating those kinds of risks. There are AI-enabled real-time monitoring systems and alerts, so AI-powered sensors and cameras that can monitor the workplace for unsafe conditions or detect anomalies like equipment malfunctions, gas leaks, or unsafe worker behavior. There's wearable technology that can monitor a worker's vital signs, their movements, environmental conditions, can determine, is this employee being subjected to heat stress or exposed to hazardous substances? AI-driven robots can perform dangerous tasks that might otherwise put human workers at risk. So robots can handle hazardous materials, operate in extreme environments, etc. Virtual reality training, AI-enhanced virtual reality training can simulate hazardous scenarios. AI systems also can use natural language processing to analyze safety reports and incident logs and employee feedback to identify common safety issues and areas of improvement. AI-powered computer vision systems can analyze video footage to ensure compliance with safety protocols. In fact, in December of 2024, OSHA, the Occupational Safety and Health Administration, announced that its inspectors were going to use AI-powered smart glasses when they came to the workplace to do inspections with cameras, sensors, and internet capability. That is not going to be happening in this administration likely, but it's just an interesting piece of information regarding the technology that can be used in the workplace with respect to workplace safety issues. And finally, AI-enabled drones can be used for inspecting hard to reach or hazardous areas like construction sites, oil rigs, or power lines. So by leveraging these technologies, organizations can significantly enhance safety protocols and reduce the risk of worker injuries. Some of the potential risks, of course, are not just algorithmic bias, but determining liability when an AI-enabled system gets it wrong. If there ends up being a worker injury or death because of the use of the system that got it wrong, determining who's liable may be a challenging determination. Was it the AI tool? Was it the employer? Was it a combination of different factors? So determining liability is one one challenge here. Another is, the AI systems are relying on large amounts of data, including personal information about employees and safety records and health information, and that the collection, storage, and processing of that data can introduce significant privacy and security concerns. And advanced sensor technology could raise worker concerns about it being intrusive worker surveillance, violation of personal privacy, algorithmic bias issues. Also, will the tool be able to comply with safety regulations? Will it comply with HIPAA regulations and GDPR regulations, general data protection regulations in the European Union that impose strict requirements on how personal data is handled? So these are just some of the potential risks and some of the potential issues. Next slide, please. So another risk with respect to AI in the workplace is the issue of deepfakes in your workplace. So a deepfake is a fake image or video or audio that's been created using artificial intelligence. And some of the risks are it can manipulate facial expressions, speech synthesis where it takes voices and then manipulates them. And so a real danger of generative AI is the ability to create these deep fakes that make it appear like someone said or did something when they actually didn't. And cyber criminals can and do synthesize these deep fakes to spread disinformation, to fool employees into revealing information and granting access to sensitive systems, and even sometimes to extort them. So next slide, please. So I would like to share two cautionary tales. One involves a company called KnowBe4, which is a leading provider of security awareness training. They come and they train employees. They have online trainings on how to avoid phishing scams and different kinds of things that cyber criminals might do. And this security awareness training company was actually duped by a fake employee. They were hiring a remote worker, and how many of you have remote workers, remote only workers? They were hiring an IT person who was going to be working remotely, and this is really just a more general cautionary tale that the rise of remote hiring is putting human resources at risk of falling for these deep fakes. So the person they hired was not who they thought they had hired. They had conducted 4 video interviews with a job applicant for a remote position with somebody who called himself Kyle, appearing in this photograph. And the photograph was actually, he had taken a photograph of another person and superimposed his photo on top. So the photo looked like the person they interviewed in the video interviews, but the background check that they did was a background check on someone else, on a US citizen whose information he had used. And so that person passed the background check, but it was not the person who was presenting to them. They actually hired this individual. They shipped the laptop to him to an address that was not an address that he had provided them on his resume or in any other information. And he then attempted to install malware with the purpose of obtaining information from their systems about their employees. And what they found out was that this was not a real employee, the person they thought they were hiring, but was in fact an IT North Korean government operative, someone who was working with the North Korean government. And when they contacted, they shared the suspicious activity about that somebody was on, trying to get into their system. They could see what was happening and they shut it down. When they shared this with cybersecurity experts and the FBI, that's when it was confirmed that this person was an IT worker who was a North Korean operative. And the CEO of KnowBe4 apparently had people, other company leaders who then approached him once he went public with this. He decided to go public with this information to share the story of what happened. And other company CEOs approached him and said, this happened to us too. So apparently this is a growing trend, this type of deep fake. And the other story I'll share with you is a finance worker at a multinational firm was tricked into wiring $25 million to a fraudster who used artificial intelligence to deceive him. He was duped into attending a video call with colleagues, or who he thought were colleagues, on the call, on a Zoom call. And it turned out all the people he was on the call with were fake, deep fake recreations. They were not real colleagues. And the worker said he'd grown a little bit suspicious after he received a message, an email message from what he thought was the CFO. But so he suspected it was a phishing email after this CFO talked of the need for a secret transaction. But then when he had the Zoom call, his fears were allayed because he thought the people he was on the call with were real, who were telling him to wire the $25 million. So these are just some cautionary tales about deep fake and the importance of training your employees about deep fakes and the fact that they can exist. Next slide, please. Next slide, please. I'm going to speak a little bit about laws and regulations here. So we have no federal law governing the use of artificial intelligence in the workplace. Federal, state, and local anti-discrimination laws apply to the use of AI, where it has a discriminatory impact. And what's happening is there's now a growing patchwork of state and local laws and regulations addressing AI use in employment decisions. And I expect that there will continue to be more states and municipalities enacting laws to regulate this issue in the absence of federal legislation or regulation in this area. So employers need to continue to comply with anti-discrimination laws, which do apply to the use of AI where it has a discriminatory impact. And I will also talk about the recent executive actions. Next slide, please. So New York City and Colorado, the state of Colorado, are two of the first jurisdictions in the United States to enact legislation governing employers' use of artificial intelligence in the workplace. As I mentioned, there's no federal law governing the use of AI in the workplace, but each of these jurisdictions have enacted laws that govern employers' use of automated employment decision-making tools, abbreviated AEDT. So those tools are like resume and job screening software, and the idea is to prevent discrimination in hiring. So New York City's law took effect in January of 2023. They started enforcement, or said they were going to start enforcement in July of 2023. And the law requires bias audits, that employers conduct bias audits for AI-enabled employment tools. Employers have to notify employees and job candidates about the AI use, and there's certain notices that have to be required. Employers have to publish the audit results, and they have to do an audit before they use the tool, and then the year before they use the tool, and then annually. Colorado is the first state in the United States to address the use of AI in the workplace. The law, which was enacted in 2024, takes effect next year in February, and it governs how artificial intelligence can be used in the workplace, but also in education, financial services, and healthcare. Requires detailed notices to consumers, which include employees who are affected by AI-assisted decisions. And Illinois has recently amended its Human Rights Act, and that law will this amendment will take effect in 2026 to prohibit the use of artificial intelligence by employers that has the effect of subjecting employees to unlawful discrimination based on legally protected classes, or to use zip codes as a proxy for protected classes for employment purposes. So this law is interesting because it's identifying that zip codes of, let's say, if they're people of a particular race or national origin who tend to be living in a certain zip code, that employers can't use that zip code as a proxy for discriminating against the individual based on their legally protected category, whether it's race or national origin, etc. Next slide, please. Utah passed a law a while back. It took effect in 2024 that requires disclosures when an individual interacts with AI in a regulated occupation. So let's say an individual is interacting with a healthcare professional. So it would be somebody who has a license or state certification. So it'd be somebody like a healthcare professional. An individual goes online, is speaking with a healthcare professional. Well, the law in Utah requires a disclosure to let the person know you are interacting with a chatbot or something to that effect. You are interacting with an AI-enabled tool. So that's already in effect. And in 2020, Illinois passed a law, enacted a law that requires employers that are using AI to do video interviews to notify the applicants of AI use and to obtain applicant consent, to share any applicant videos only with service providers who are engaged in evaluating the applicant, to destroy copies of the videos, and to provide annually a demographic breakdown of the applicants who were offered the interview, those that were not, and the ones that were hired. And Maryland also has a law that took effect in 2020 that prohibits employers from creating a facial template of a job applicant without first getting their explicit written consent. So you can see that there's a trend. This has already been starting, and it's just growing, both in terms of the scope of the protections for employees and the requirements on both AI deployers. That means, let's say, the employer who is using the AI tool, and on AI developers, the entities that are actually creating the tool. Next slide, please. Also just wanted to make you aware that New Jersey's issued guidance recently. It's the Attorney General's Office and the Division of Civil Rights issued guidance to make clear that the New Jersey law against discrimination prohibits algorithmic discrimination, and that employers can't escape liability for that discrimination by outsourcing a AI hiring, screening, or evaluation tool. So that's just a heads up that other states are looking at this issue and issuing guidance. We also have some proposed laws. New York, California, Texas have all proposed laws at the state level that address these high-risk artificial intelligence systems that affect consumers, employers. So it's not just about employment, sometimes it's also about housing and other areas where individuals can be negatively impacted by these AI tools. And Virginia also had a law that was enacted, but it was just vetoed this week by the governor out of concerns raised by business industry groups that the law might stifle innovation. Next slide, please. Executive action on artificial intelligence. So President Trump, within days of his inauguration, issued an executive order called Removing Barriers to American Leadership in Artificial Intelligence. The first thing that it does is it revokes President Biden's earlier 2023 executive order and directs certain officials to identify any actions that were taken pursuant to President Biden's order and identify those that are inconsistent with or may present obstacles to his policy, which is to sustain and enhance America's global AI dominance, to promote human flourishing, economic competitiveness, and national security. And he has directed that within 180 days, an action plan to achieve his policy goals must be submitted. So President Trump's focus is on promoting innovation through AI, and he's declared that artificial intelligence is a critical tool for maintaining US technological dominance over China. His executive order also says that he wants to ensure that AI systems are, quote, free from ideological bias or engineered social agendas, close quote. So Vice President Vance, you should just have a little bit of, a little bit of background about what has been, what is being said about AI and some changes that have occurred recently just in terms of the approach. Vice President Vance recently said to tech leaders and government officials, we have to be leaning into the AI future with optimism and hope. At an AI summit last month in France, he also called for pro-growth AI policies and warned world leaders against excessive regulation that could kill a transformative industry that is just taking off. So there's really a focus on, how can we spur innovation? President Biden's executive order was focused very much on how can we ensure that artificial intelligence is safe and secure? How can we ensure that there is no algorithmic discrimination? How can we ensure that we're mitigating the potential for workforce disruption that will be caused by artificial intelligence replacing certain roles, the federal government's use of AI, and also that the U.S. should be a global leader, that it should spur innovation. So those are some of the differences and distinctions. You may have actually seen, I don't know how many of you have seen the article in the New York Times earlier this week that was entitled "Emboldened by Trump, AI Companies Lobby for Fewer Rules." And in summary, the article highlights a dramatic shift in the tech industry's approach to AI regulation under the Trump administration. So essentially the article is saying, for the last 2 years, technology leaders who are developing AI urged lawmakers to regulate the industry. They warned of potential disruptions to national security and elections and job markets. But since President Trump was elected, these tech leaders have now shifted their stance, and now they're advocating for minimal government interference in order to advance their products. So I commend the article to you. It's an interesting article. So, and AI policy experts have concerns that unbridled growth could be accompanied by issues like rapid spread of political and health disinformation, algorithmic discrimination, things that we've been discussing, and cyber attacks. Next slide, please. I'm just going to briefly just say that there were some federal guidelines that were issued by various agencies that are now no longer in effect, that addressed the dangers of AI, not just algorithmic discrimination. The EEOC had issued some guidance about that, but the U.S. Department of Labor also spoke about how AI-enabled tools can result in potential liability for employers under the Fair Labor Standards Act. So those guidelines are no longer valid. But I just wanted to make you all aware that they had been in place at one point. Next slide, please. I turn it over to Slaven.
Yeah, thank you, Lisa. And again, assuming you've reached the contract negotiation stage with an AI vendor, really your onboarding and due diligence process should consider a number of issues, and we are just going to highlight some of the key items here today. The first one really the first critical issue concerns data security, privacy, and confidentiality. And as a general rule, you should always be seeking to prohibit the vendor from using your data to train or retrain or otherwise improve these models. These algorithms, as we mentioned, require a tremendous amount of data for training purposes, and they're always hungry for more. And so in many instances, this is leading vendors to contractually seek a permission to use your data for these training purposes. And really just a special caveat here with respect to pilots and free trials. And the warning here is that the risk isn't necessarily lower just because we're talking about a free trial period. And in fact, as we're seeing in a marketplace, the opposite may be true, as often the terms that govern these free trials and pilots are often very permissive with respect to the vendor using the data for further R&D purposes. So that's just an important caveat to keep in mind. In terms of just mitigating some of the ownership and IP issues, IP infringement risk, stemming from either the use of the training data or the AI outputs, would primarily be managed through appropriate representations and warranties and indemnities, and we'll touch on that separately. And when we say representations and warranties, we're really talking about certain contractual promises or statements in the agreement itself that provide assurances about either the present or the future performance or the functionality of the tool or the training data itself. Another key point to address with any platform provider, and again, this isn't necessarily unique to AI vendors, but it's a very important point to keep in mind. And it really just concerns the key question of how are the obligations to either return or destroy your organization's confidential information addressed. For example, if there are any post-termination obligations to maintain your information for a limited period of time, that's an important determination to be made. Sometimes vendors will do that as a courtesy to your organizations, but others will seek to more or less have an immediate right to delete your information. Then separately, how are the costs allocated for any return of data? Are the provisions in a contract clear enough to help avoid, for example, a situation of sort of a data hostage situation, if you will, especially in instances of a contract dispute where a vendor may be leveraging its possession of your data as part of that dispute. So all of that really should be addressed in as much clarity as possible up front to protect your organization. Separately, your organization will have legal obligation to keep certain employee documents and records for a certain period of time, whether it's for job applicants or the employees themselves. So for example, resumes, W-9 forms, things along those lines. And so to the extent you're using the AI vendor for data retention purposes, your organization really should be working with the vendor to customize or ensure that the retention period is appropriate. So again, to ensure that your organization has access to this data during the period that it needs to obviously meet your legal and other obligations. Next slide, please. So we've touched on algorithmic discrimination quite a bit. And in terms of what that means for onboarding vendors, really your organization should be seeking to determine, as Lisa mentioned, as much as you can really during the due diligence process about the training data that was used, whether it was representative, how the model itself was developed to, again, minimize as much of this risk as possible. Separately, on the contract negotiation side, you really should be seeking to, again, institute appropriate representations and warranties, if nothing else, more generally concerning the compliance of either the vendor or the tool itself with the applicable laws, but ideally and more specifically drilling down to things like algorithmic fairness. And in addition to the specific reps and warranties, your organization really, as part of the due diligence process, should be seeking information from the vendor about any pending or threatened legal action, for example, because this will obviously alert you to any existing bias issues or concerns that may already have been identified with respect to a particular tool. And we've been mentioning indemnity and some of these other risk sort of shifting provisions. And as a customer, you always should be seeking to include these in your agreement as well. And when we say indemnity, we're really talking about yet another contract promise that essentially the vendor will compensate your organization for any losses or liabilities if, for example, the AI output is biased, as we mentioned, if it's infringing or is not accurate, or in some instances, the tool just isn't performing the function as intended. And the last key point here, again, as a customer here, you should really be seeking to include certain audit requirements that would allow you to verify providers' compliance with both the terms of the agreement and again, their compliance with the applicable laws. And the primary reason for this are the significant disclosure requirements that apply to not just the developers of the AI tools, as Lisa mentioned, but also for any organization that, like yours potentially, that actually deploy these to any end user, including employees. And so we've touched on a number of disclosure requirements, for example, that are needed under either the Delaware state law or the local New York City law that we touched on. And really securing appropriate rights with your service providers ensures your ability to then just really meet your own assessment and your own disclosure obligations. And separately, it's really important to keep in mind that if your organization is, for example, facing claims of bias, either due to disparate impact or disparate treatment, having access to providers' bias audits will be a critical point in your ability to defend against such a claim and to demonstrate perhaps the validity of your selection procedure. So really all the more reason to make sure that you have contractually secured this right for your organization before moving forward with the contract. Next slide, please.
Okay, we're getting to the end. We're just going to wrap up here with some key takeaways. But before we get there, one of the questions is will AI replace our jobs? Well, it's already happening. Companies are increasingly turning to AI to handle tasks traditionally performed by people. Goldman Sachs has projected that AI could eliminate up to a quarter of all current work tasks in the US and Europe, potentially putting tens of millions of jobs at risk, and has already conducted layoffs for positions being replaced by AI, as have many other companies, which I'm not going to go through right now, those that have conducted layoffs to replace the roles with AI. But here's the good news. The good news is, first of all, human oversight is still needed with respect to monitoring these AI tools. And there are new opportunities that have been created through artificial intelligence. Tech jobs and big data, fintech, and AI are expected to double by the year 2030, according to the World Economic Forum. So there's great news with AI in terms of the opportunities, not just for new jobs, but also employers will want to be thinking about upskilling their workers to work with the AI tools, reskilling workers whose jobs may be replaced, and conducting additional job training. So as I mentioned, human oversight is still required. Next slide, please. And just a few key takeaways. So first, as Slaven had really spoken about, develop comprehensive AI policies and internal governance structures. So you really have a sense of, are we going to allow AI use in the workplace? What are the parameters? What are the guardrails? Have clear policies and procedures for AI use, and also the monitoring of the tools that you're going to use. Identify the stakeholders and consider who at your organization should be involved in addressing how the AI gets used, drafting the AI use policy, again, the guardrails are going to be around AI use, and who is going to be responsible for testing and monitoring the AI tools to ensure accuracy and mitigate discriminatory risk. You want to make sure that your employees are not putting your confidential information into ChatGPT. So there needs to be training and policies that are clear about what information can and cannot be put into those open systems, for instance. So effective and regular training, both on the proper use and the dangers of AI tools, including deepfake, as I had discussed earlier, as well as training on employment law requirements and what compliance with those laws means. Comply with the law and ensure human oversight in the use of AI tools to mitigate the risks that I mentioned, like wage and hour violations and algorithmic discrimination. Employers need to make sure that they're remaining vigilant to comply with anti-discrimination laws and training their employees, conducting regular testing and auditing of the tools. keeping good documentation on how AI models were built, and documentation regarding the AI output, and conduct thorough reviews of your hiring processes to detect potential biases and areas of improvement. And in some jurisdictions like New York City, you'll have to do a bias audit if you're using these tools in employment decisions. And then reskilling, upskilling, and being proactive in anticipating workplace changes. For those of you that have unions, don't be surprised to see collective bargaining agreements that address, jobs that are newly created by AI. So just a heads up on those things, and to be thinking about that and being proactive in anticipating what those collective bargaining agreements may require. Next slide, please.
And quickly continuing with the takeaways here, really the next point is to make sure that you're verifying the AI tools and vendors as we discussed. Really, you should be thoroughly vetting the tools and the vendors that are providing them to make sure that they meet the required standards and your expectation when it comes to data privacy, security, and overall legal compliance. The other important point here is that you really should take the time to understand the specifics of the AI tool. This includes knowing the data sources, the reliability and the safety of the tool, but even more broadly as a best practice, really it's going to be critical to identify and really define the categories of data that would be processed by the tool to determine the appropriate risk level based on the contemplated use case, and then really determine which laws, regulations, and maybe other contractual duties might be in play. As Lisa already mentioned, assessing these tools for any disproportionate impact against certain legally protected groups is going to be another crucial aspect. So these are the bias audits that we've been discussing, and of course documenting these results ideally with legal counsel is going to be important for both accountability and compliance purposes, but also to preserve legal privilege where that would be appropriate. And then finally, maintaining appropriate record keeping of audits and everything that's going into the due diligence process itself will also be critical. Keeping these detailed records will not only help your organization keep track of your compliance efforts, but it's going to really enable your organization to then respond effectively in the event of any legal action or maybe any regulatory investigation. And with that, I think we're completing the substantive portion of our presentation. If there are any questions, we'd be happy to address those now. Let's see.
Well, thank you, Lisa, and thank you, Slaven, and thank you everyone for attending today's webinar. Reminder that you will receive a follow-up within 24 to 48 hours with a link to view a recording of today's webinar, as well as a copy of the slides. On behalf of Whiteford and our presenters, thank you for joining us and have a great rest of your day.
Thank you.
Thank you all.